Hi, hello everyone. Welcome to Master Stage. And today we are going to discuss administrative law. Unit 2, we are going to discuss. It is few minutes of video, and it is will be excellent for your examination purpose. Okay, as I said 5 units simultaneously. So this is the second unit, foundation of administrative law. In this, we are going to examine core principles and governing administrative action and safeguarding citizens' rights in democracies like UK as well as USA, India, etc. And it is very useful for LLB third sem. Okay, the core concepts of administrative law. So, administrative law regulates the government powers and it protects the individual liberties. And this unit, we are going to cover rules of the law and which is separation of the powers. Okay, foundational doctrine between balancing efficient administration with the fundamental rights in democracies. So, rule of law. So, as per Dicey's formulation and contemporary interpretation, then separation of powers. So, we are going to comparative analysis India, UK, and USA. Then modern application. So, evaluation in constitutional practices. Okay, this the core concept we'll discuss. So, the rule of the law as per Decay's classical formulation. Albert when Decay's introduction. See, you have to remember the name of the book. Albert when a disease. Okay, he written the introduction to the study of the law of constitution. Okay, uh, 1885. So, which articulate the three fundamental principles of the rules of the law. So, this formulation remains the central Anglo-American Constitution. So, throughout adapted the contemporary challenges. So, here the as per Albert Venedick's so introduction to the study of the law of Constitution. Okay, it is a supremacy of law, then equality before law, then predominance of legal spirit. So, as per Albert Venedicis, so supreme of law, that means no person can be punished without clear breach of law. So, established in ordinary courts, this exclude arbitrary power and wide discretionary authority. Then all persons, irrespective of their rank, their creed or caste, so all are equal in front of the law. So, so all persons, regardless of rank, are subject to the same ordinary law and courts. No one included government official. No one including government officials is above the law. So all are equal in front of the law or before the law. Then predominance of legal spirit. So constitutional rights stem from judicial decisions. So enforcing rights in specific cases rather than abstract declaration. So rights are realized through actual enforcement. So these are the three rules of Albert Venne diseases. So this you have to remember. Then critics and limitations of Decay's theory. Okay, one is this particular what we discussed. This particular thing about the introduction to the study of the law of constitution, which is given by the Albert Venne case. So, which was the if you observe about the historical context, which is relevant to the which is relevant to the 19th century. Okay, it is the British government's uh, predicting the rise of the administrative tribunals and delegate legislation. So, the expanding welfare state necessary. Okay, revising the rigid framework. So, what is the criticism here? So, this particular Decay's theory, it underestimate the need for modern administrative discrimination powers. Okay, uh, it failed to account for the specialized administrative tribunals. So uh, it is ignored the difficulties before ensuring that absolute equal before the law. Okay, did not anticipated administrative states growth, and its overlooked need for swift administrative action in welfare governance. So these are the thing. Okay, despite these limitations, decay's core insight: government powers must be constrained by the law, okay, remains vital to constitutional democracies. Okay, so modern trends, the rule of the law is modern interpretation adapted by the decay's theory to the administrative state, preserving protection against arbitrary power. The rule of now embrace the flexible. The rule of the law is nowadays is flexible, substantive understanding, acknowledging and administrative discretion necessary, and risk. So procedural fairness. So natural justice principle. You have to remember this. Okay, audi altrum patum nemo judex causa sua. So this means that ensure fair administrative procedures and due process. Okay, then judicial review. Courts supervise administrative actions, ensuring that decisions are legal and reasonable and procedurally sound or good. Then substantive rights protection. So the rule of the law now included protecting fundamental rights, human dignity, and substantive justice behind more formal compliance. So these are the modern trends in the rule of the law. Procedural fairness, okay, then judicially review is necessary, then substantive rights protection, so which includes protecting of the fundamental rights, human dignity need to be maintained, and substantive justice should be there. So they should be behind the formal law compliance. Okay, then theory of separation of power. So as per the articulated by the Montesquieu. So this doctrine, separation of powers, divide the government authority into three distinct branches. That is this prevents the trainee protection liberty and establishing the system checks and balances. So there is a legislative branch where parliamentary makes the laws, stats, and control the public finance, then representing the popular will. Whereas executive branch, so which implements the law, conducts the administration, and manage the daily governance. Then judicially branch, so interprets the laws and as well as adjudicate disputes and ensure that legal compliance acting independently. So these are the three branches. One is legislative branch, executive branch, and judiciary branch. So so when the legislative and executive powers are united in the same person or in the same body of magistrate, there can be no liberality. So there should not be no unity as per this one. Okay, again I'm reading: when the legislative and executive powers are united in the same person, okay, they should not be a same person, legal as well as executive branch, or in the same body of magistrate, there can be no liberty. So as per Montesquieu, there should be a three branches: legislative branch, executive branch, and judicially branch. Okay, if three persons are the same, then there can be no liberty for the normal people given by the Montesquieu. Just remember this information and branches: legislative branch, executive branch, and judicial branch. Okay, so if you come to the separation powers in India, okay, so there are as per the Constitution. So Indian Constitution implicitly incorporates separation powers, core powers of basic structure. It features the parliamentary system with the executive, legislative overlap, balancing the strong judicial independence upheld by the Supreme Court. That means three powers are different. legislative powers. So as per the article 79 122, so the parliamentary make the laws. Okay, it is legislative law. Then executive, president and council of ministers, a group of ministers, as per the article 52 to 78, 153 to 167, it implements the law implemented by the executives. Whereas judiciary, so that is related to the court, supreme court, then high court, article 124 to 147, interpret the laws and protect the rights. So this is the Indian constitutional framework. So where it can checks the balances. So judiciary reviews actions, the court reviewed the actions of the legislation. Example, Kesavananda Bharati versus State of Kerala. Then parliamentary control via questions and no confidence motion in the parliament. Okay, parliament, it happens, they question, opposition questions, and sometimes no confidence is motion is done in the parliament. Then parliament assessment for legislation, so impeachment for judges and president. So constitutional limit on each organ power. So these are interrelated and interconnected for the welfare of the people. The constitutional framework in India: legislative, okay, that is in parliament, article 79 122 makes the laws. Then executive powers, which laid with the president and council of ministers, article 52 to 78, article 153 167, implement the law, that is executive. And judiciary, supreme court and high court, article 124 and 147, interpret the laws and protects the rights. Okay, so separation of powers in United Kingdom. So like parliamentary sovereignty is there. Parliament maintain the supremacy with the unlimited legislative power. So despite of lacking written constitution, so UK don't have the written constitution. Okay, so practical limitation arises from the European Union membership, that is between 1973 to 2020, and the Human Rights Act 1998. So we are different. We are separation of powers. Okay, somebody makes the legislative, somebody execute, somebody judiciary. But here in UK, the parliament is a supremacy. Okay, they have the written constitution, they don't have written constitution like us. Then executive legislation, so the prime minister and cabinet of minister of parliament ensure that legislative accountability but blur the constitution lines. The fusion, the promote efficient governance and with the concentrate the power with the prime minister as well as with the members of parliament. Then judicial independence. So the Constitutional Reforms Act 2005 so established the UK Supreme Court in 2009, separating top judicial functions from the House of Lords and significantly strengthened the judicial uh, uh, strengthening the judicial independence. So, as per the statement, the constitution just reforming in UK. Okay, then we'll go to the separation of powers in United States. So, US constitution established the rigid separation of powers. So, which is influenced by the Montesquieu to prevent concentration authority. So it features three equal branches with a distinct constitutional mandate, then strict separation, personal and functional balances, checks and balance. So in US, there is a Congress. Okay, that is a bicameral legislature. That means they have the Senate and House. So holds the exclusive lawmaking power. This Congress has the exclusive lawmaking power, which includes like through bicameral legislation, they which includes making taxation policy and war declaration, everything done through bicameral, that is Senate and House. Whereas president is a president elected through with veto, so appointed, and he is the commander in chief powers, not a member of Congress in US. Then federal court, so Supreme Court and federal courts are exercise judicial review. So, like Marbury versus Madison, then striking down unconstitutional laws. Okay, so if you are comparing the three models, that is India, United Kingdoms and United States, so each nation separate the powers, reflect the unique constitution history and political cultural understanding. These variations reveals how democratic system balancing efficiency. So if you see the this particular thing says about India, and this one says about the uh, like here, just wait, kindly be online. So so this particular color says about India's, and middle one is the UK, and last one is the United States. So if you see, the rigidity in US is more, whereas UK is in the middle, whereas India is rigid is not far, not small, in the middle way. Where judicial independence, so judicial have the more power compared with the UK, and more power, and judicial independence is more in US comparing with the Indian as well as UK constitution. Then executive legislation, so somewhat UK is locking, whereas India is something better out of it's a 4 points. This have the more than almost 10 points is there. Okay, so this is the thing. So India has a hybrid model, parliamentary fusion with a strong judicial review, whereas kingdom, so uh, like United Kingdom, parliamentary sovereignty is there, executive and legislative fusion remains the central. Then United States, so it is a strict presidential system with the rigid separation and strong judicial review. So this is for the representation purpose. This video made for only for the preparing those who are preparing for the uh, law LLB third sem. Okay, just go through that one and previous videos also check, where you are going to learn. In this particular video, we learned about the foundation of administrative law. So we discussed separation powers, India, UK, USA, and modern application happens here. So there is a decades classification formulation. Okay, just you have to remember Albert Venice decades introduction to the study of law of the Constitution. Okay, this is written by the Albert Venice decay. He has given the clarification like divisions or three things: supreme of law, equality before the law, then predominance of the legal spirit. Then we discuss some of the criticism which is not relevant to the nowadays, as it is made in the Dickey's theory is made in the 19th century context. Basically, you go, that time British government is the governance. Okay, then we discussed modern trends in rule of the law. There is a then procedural fairness should be there, judicial review is a must, then substantive rights protection is there, then separation of powers between the legislative branch, executive branch, and judicial branch. So when you're writing, write these and you'll get good marks. Then constitutional framework, as per Indian constitution, there is a legislative power lying with the parliament. Article 79 to 122 makes the law. Then executive thing, parliament, president and council of minister, group of minister. Article 52 to 78 and 153 to 167, so it implements the law. The executive and judiciary, Supreme Court and High Court, as per the Article 124 and 147, which interprets the laws and protect the rights. So checks and balance we already discussed, and we discussed the three things in the separation of powers as in UK and in US. Now it is a comparative study. It is just representative. Go through this video again and again. If you like this video, please do share and subscribe and like. Okay. Thank you. All the best for your coming examination. We'll meet in the next lecture with a proper explanation that will be helpful to you. Thank you. All the best for your LLB examination.